Morning. I don't know that we need to do a roll. All right, welcome back, ladies and gentlemen. We're going to do have the clerk do the roll call to check who is here, and there are a few jurors we need to have discussion with.
Good morning again. When I call your juror number, if you would stand and say present, and then have a seat, and I'll proceed to the next number. Thank you. Juror number 11.
Present.
Juror 16.
Present.
Juror 17. Juror 22. Juror 22. Thank you. Juror 39.
Present.
Juror 45.
Present.
Juror 58.
Present.
Juror 59.
Present.
Juror 75. Juror 77.
Present.
Juror 80.
Present.
Juror 82. Juror 95.
Present.
Juror 96.
Present.
Juror 110.
Present.
Juror 112. Juror 124.
Present.
Juror 131. Juror 148. Juror 152.
Present.
Juror 176.
Present.
Juror 180.
Present.
I'm going to pause there for just a second. Is that button on? Juror 181.
Present.
Juror 185. Juror 193.
Present.
Juror 202. Juror 214. Juror 220. Juror 221. Juror 224. Juror 228. Juror 240. Juror 244. Juror 254. Juror 255. Juror 257. Juror 258. Juror 278. Juror 282. Juror 294. Juror 303. Juror 326. Juror 337. Juror 346. Juror 349.
Juror 349 will come forward, please, along with counsel. Juror 650 and Juror 729. 349, 650, and 729, and we'll speak there individually. So who,
Please be seated.
131 is excused. And 349 is excused. And you may proceed.
All right, 351. 358. 367. 370. 374. 384. 390. 394. 396. 398. 400. 441. 460. 470. 474. 482. 508.
Present.
518. 522. 524. 528. 530. 533. 534. 544. 548. 550. 556. 557. 564. 567. 568. 571. 572. 575. 578. 582. 588. 589. 595. 596. 609. 612. 630. 644. 651. 654. 658. 663. 650. 650.
650.
Thank you. 669. 674. 694. 695. 704. 705. 711. 715. 727. 729. 730. 732. 741. 752. 781. 784. Thank you. Last page. 785. 799. 803. 808. 810. 816. 816. Pretty sure you're in here. 816. 816. Thank you. 826. 845. 856. 864. 886. 887. 893. Okay. Is there anybody in here, that's a juror, whose number was not called? I'm just going to say it one more time. Is there any juror in here whose number was not called? Okay, Judge, I think that's the roll.
Ladies and gentlemen, welcome back. We have all of you back this morning, and out of the number of you that are here, we're going to whittle the number down to 80. Then we will further inquire and then prepare to select the jury from that group. Want to know now, however, whether there are any jurors out there who believe that you cannot serve for whatever reason. If you believe you cannot serve, please stand. All right, ma'am, tell me your juror number. 294. All right, we'll talk to you in just a moment. Anyone else with a problem serving on this jury? Yes, ma'am. Juror number 58. Say it again. 367. All right. 282. 396. All right, we'll speak to all of you in a moment. Are there any jurors who today are experiencing any COVID-related symptoms, such as shortness of breath, any other physical problems that might indicate that you may have COVID or may have been exposed to someone with COVID? Yes, ma'am. Tell me your juror number. 202. And are you currently experiencing problems, or you believe or you're been in contact with someone who's having problems?
I have a cough.
All right, number 202, and you believe that might be a COVID related, possibly.
I don't think so.
Or do you believe that you're available to serve, or that we should let you go?
I think I'll be available.
All right, thank you. Has anyone else been exposed to anyone who you have been diagnosed with COVID or who you think might have it? So, Madam Clerk, you can we'll talk with those jurors, but you can get your list of 80 while we take this break, and just go and do it, because if they're in it, then we'll just strike through them and keep going. All right, we'll be at ease just again as we speak with the, what are their numbers? 294,
58,
58,
367,
367,
282,
282.
and 396.
That messed it up.
Yes, 282
And 396. Okay. So, ladies and gentlemen, we'll be running a list of the 80, so we'll just all stand and be at ease for a bit, give you a chance to stretch and all of that.
Welcome to Law and Crime here on this Wednesday afternoon. I'm Anjanette Levy, and thanks for joining us as we are following jury selection in the trial of disgraced South Carolina lawyer Alex Murdaugh. Alex Murdaugh is accused of murdering his wife Maggie and son Paul back on June 7th of 2021. And this has been a case that has captivated not only the nation, but people in the low country of South Carolina. Right now, there are 125 prospective jurors who have reported to the courthouse in Colleton County for the final bit of jury selection that we're watching unfold right now. And we're going to be taking your questions over the next hour or so. So please feel free to submit those to us on Twitter, Facebook, Twitch, and on our YouTube chat. As I mentioned, 125 prospective jurors reported to the Colleton County Courthouse this morning. 2 have been eliminated from that pool so far. From that group, the final 12 and alternates will be selected. Colleton County is a small place. South Carolina really is a small place, but Colleton County has a population of around 38,000 people. So selecting a jury is going to be really difficult, actually. It will be a challenge for these attorneys and for the court because Alex Murdaugh and his family are basically a legal dynasty in South Carolina's Low Country. Recently, I spoke with Alan Turkheimer. He is a jury consultant about what it will be like to find a fair and impartial jury in this community.
Jurors, everybody for that matter, are not necessarily good at knowing how biased they are. So you might have some jurors, and both sides have to look out for a juror that indicates, yeah, they know about the family, they know a little bit about this case, and they can be fair. People want to think they're fair. People, when they talk in public in front of a judge and others, want to believe they can be fair, and it can be a sincere belief. However, there are probably some biases in a lot of the panelists, it could be called, that each side has to really probe into and then understand in order to give either the state or the defense a fair shake.
And that was Alan Turkheimer, a jury consultant who works with us frequently here on Law and Crime on these big cases, talking about the challenge of selecting a fair and impartial jury in Colleton County, South Carolina for the double murder trial of Alex Murdaugh. So as I mentioned at the top of the show, we are going to be taking your questions for the next hour. We want you to keep those coming to us on Twitter, Facebook, Twitch, and in our YouTube chat, and we will get to them. We have a great panel with us here today to discuss this case and take your questions. First of all, we have Gigi McKelvey. She is down in Colleton County at the courthouse in Walterboro. Law and Crime host and defense attorney extraordinaire Linda Kenny-Bodden, and Joseph Scott Morgan, a forensic death investigator and host of the Body Bags podcast. Thanks to all of you for being with us today. Gigi, I want to ask you first, what is the mood like? What's it like down there today as we get this jury selected? We've got 123 people sitting in that courtroom right now, and we're going to be whittling that panel down to the final 12 along with the alternates.
Yeah, I mean, everybody's ready for jury selection to wrap up and get to these openings. Everybody wants to hear the facts of the case, how they were able to get the double murder charges. So it's a mood of anticipation for sure right now here in Colleton County.
Linda Kenny-Bodden, I want to ask you, you've been through this before, you've done plenty of high profile cases.
Yes. Hello. I didn't hear the question, Anjanette.
Linda Kenny-Bodden, I want to ask you, I'm so sorry. What is it going to take to get this jury selected? We're obviously going through this final process, but tell me what that's going to look like.
Well, let me tell you, the problem that you have when you're on any type of high-profile case is weeding out the person who wants to be on the jury, has already made out their let's shall we say, initial decision, and they want to get on the jury, so they make sure that jury goes their way. That's the most difficult part for both sides, but especially for the defense. The defense is going to be looking for those pre-existing biases that may be hidden. They'll take a juror that may be pro-state, but that will be honest about their feelings over somebody that may not be. So I think you'll have a jury. The lawyers know who they're talking with. They know the people in the community, and they'll know pretty much how to pick out that person who wants to be the spy for either side.
And Joseph Scott Morgan, there's going to be a lot of forensic evidence in this case. We have Maggie and Paul, mother and son, murdered on June 7th, 2021. Also shot with 2 different firearms. The state alleges, though, it's one shooter. What's the challenge going to be there?
I think trying to wrap your head around the fact that 2 long arms, not a pistol and a shotgun or a pistol and a rifle were used, but a shotgun and a rifle. These are shoulder-fired weapons. And from my experience, where you have multiple weapons involved and you're talking about one shooter, there's an idea of transition that has to take place between the use of these 2 weapons. And so it's very cumbersome. And again, I think that the defense is going to utilize that bit of information to at least instill possible in the minds of others that there might be other people involved, because this is very difficult to manage. With the shotgun alone, one of the interesting things for me, at least, is the fact that you don't just have one type of ammunition that's being fired from the shotgun. You have 2. You have birdshot and buckshot, which again is fascinating, because most of the time when someone loads up a weapon, particularly a shotgun, you're going to use one type of ammunition consistently. The fact that there were 2 is quite compelling, I think. So there's going to be a lot to pick through. You're going to have dynamic blood evidence that's going to be involved, trace evidence that's going to be involved, those sorts of things.
Yeah, the 2 long guns is confounding to me, both the rifle and the shotgun, and the fact that we have 2 victims in somewhat close proximity to one another. Maggie sadly found on the outside of the dog kennel, and then Paul found inside in that storage room area. Okay, let's get to some of your questions. We have some great questions coming in. Again, keep them coming on YouTube, Twitch, Twitter, and Facebook, and we will get to them, as many of them as we can. Our first question comes from D. Turner from YouTube. And I guess, Joseph and Linda, either one of you could answer this question. I'll throw it to you, Joseph. Did they find either long gun?
To the best of my knowledge, they have not found the rifle. I'm unsure about the shotgun at this point in time, so I can't answer that in the affirmative. Again, we're waiting for a lot of this information to come out.
Most definitely. And Gigi, our next question comes from JRS1 from YouTube. How many years behind bars is he facing if found guilty, Alex Murdaugh?
Life in prison. They opted not to go after the death penalty, and that is in addition to the hundreds of years he's already facing for the financial crimes that he's accused of.
Mm-hmm. And Linda, I think this is a really good question because, we topped off the hour talking about what a small jury pool it is there in Colleton County, and the fact that you have Alex Murdaugh, a 4th generation of this legal dynasty. They've had massive control over the court system and politics in that county for years now, almost a century, if not a little bit longer. Why did they not change venue in this case? I think that could cut both ways, right?
Right. It's a really interesting question because it's very much like the case we're seeing in Idaho. Where do you put this case in South Carolina that there's not going to be some kind of tentacles from that family? And the case is known everywhere, right? So I think that the attorneys felt that they could weed out, and the judge also, those that had that great bias, that knew the family, right? That said, no, we've had dealings with the father, the grandfather, we've had dealings with him, our kids go to school with their kids, that they could get rid of those, and who's ever left may be the pool that would be fairest. And remember, it's not unusual not to change venue anymore. The courts are really going against that. They may move it a county over here or there, but they're not really, interested in like moving it to, 3 counties away and busing jurors and all. So I do think that it will work out, and I think that the court knows what they're doing here.
Well, and that judicial district there, the 14th Judicial District, where Alex Murdaugh's father, grandfather, and great-grandfather were all the solicitor, which is a district attorney or prosecutor, as a lot of us would know it. That's really like a 5-county area. So you'd really maybe have to be moving this thing clear across the state. And they must think, they can get a jury in Colleton County. So I have another question for you, Linda, because we were just talking about this, the four of us, before we went on the air. And I know that you know a lot about this stuff, as does Joseph. And this has to do with the ballistics in this case. This comes from Melissa Dotson from YouTube. Linda, how significant do you think the judge's ruling was on allowing the ballistics expert's testimony? And this has to do with that motions hearing we had yesterday, in which he was questioned about how he was able to render this opinion about those 300 blackout rounds and the type of gun from which they were fired when he doesn't have the gun, when he doesn't have the rifle.
Oh, Melissa, thank you for that question, because I love talking about this area. I spent several days cross-examining a firearms examiner in the Aaron Hernandez case when we had a not guilty on the double homicide there on these same issues. Now, the judges are always going to allow the firearms tool mark identification, it's actually called, as opposed to ballistics, which is the movement of the bullets in the air. The firearms identification, tool mark identification in, because it's pretty much been accepted in the communities, except that in the scientific area, there has been an attack in the past, I should say from 2009 on, that indeed it's a subjective determination whether cartridges and shell casings match each other and or match a weapon, and that there's no statistical foundation or error rates for the identification by the experts for the state. So I don't think that the motion or the decision by the court allowing it in is significant, because I think if the defense is going to make their case, they're going to do it in front of the jury in ways that the jury can understand. They were expecting it, but it's going to be an interesting case, isn't it? And maybe it doesn't come down to those matches, maybe it comes down to everything else.
And it very well could come down to everything else. Back to those firearms, though, Joseph, you know, I thought it was interesting yesterday, and I expected Judge Newman, who's a pretty by-the-book judge from what we've seen in other cases, I expected him to allow that testimony in. I didn't think he wouldn't not. He was just going to say, look, that's up to the jury to decide. They hear it and give it whatever weight it's worth. But it is interesting to me that he was able to kind of opine on this without having that rifle to use as, you know, the gun to test from.
Yeah, and one interesting little aside here is that apparently other casings were found at the scene. Remember, this is an isolated rural area. They had an area where they would fire weapons, and there were other 300 blackout casings that were apparently found at the scene. So in the absence of a weapon, the actual weapon, and this is all circumstantial, please understand that. If you find those casings at the scene, okay, that may be weathered, more weathered than those that are around the body, you could take an intellectual opinionated leap here and say, well, we compared those casings with the ones we found adjacent to the body. We know that he owned a 300 blackout. We can't put our hands on it, but again, circumstantially, how do you explain that away? And I think that that's something that the defense is not going to have as hard a time attacking as they would if they actually had the physical weapon, the rifle in their hands. But it does set up quite interesting, though, doesn't it? Because, you know, you've got this, and what we're talking about here are not the projectiles themselves, the actual bullet that comes out of the end of the weapon. What they're looking for are going to be the markings that are going to be on the casing that's left behind, that soft brass casing or soft metal casing. You're looking for extractor marks and ejector marks. This is a semi-automatic weapon, so there's a whole mechanism that comes into play to throw that empty shell or hull away and reload another one in there. And there's very distinctive markings. Now, they are not as distinctive and identifiable, say for instance, as the rifling that you see on the projectile that travels down the twist and the turns of the barrel. But yet, you know, this has been recognized in court, as Linda had mentioned, and it's going to be a fight. It will be a dogfight in the courtroom. I'll be interested to see who the defense brings in as an expert in this case to kind of, you know, counterpunch with this.
You know, you made a lot of interesting points. I am really looking forward to seeing who the defense brings in, because defense attorneys love to attack the ballistics evidence. They love to attack all of the evidence, but I think they particularly like to attack that area, that field of forensics. Also, the fact that they did find shell casings with similar markings at the shooting range on that property. Gigi, our next question, I'm going to throw this one to you because you've actually been in the courtroom and you've been outside too, just getting a look at everything. This comes from Incognito from YouTube. Incognito asks, has Alex Murdaugh had any support from extended family members at this time to support a verdict of innocent or not guilty, or do they side with the prosecution? What are you kind of seeing as you sit in that courtroom?
Well, yesterday I sat directly behind his sister who was there. He seemed very happy to see her, thanked her for coming, told her he loved her. But so far yesterday, she was the only family member that I saw in that courtroom. So he was she was there and seemed to be nodding her head yes when the defense would talk. So it seems like she is agreeing that he didn't do this, at least by her body language and nodding her head every time the defense made a point that was in his favor.
Definitely. And no matter what you think of this case, you know, a family, a sibling a woman sticking by her brother, you know, everybody needs some support no matter what they're going through in this world. All right, we want you to keep those questions coming on Twitter, Facebook, Twitch, and on our YouTube chat, and we will get to as many of them as we can. For now, we're going to take a quick break. Stay with us. I'm Anjanette Levy, and you are here watching Law and Crime as we cover jury selection in the trial of Alex Murdaugh. Welcome back to Law and Crime. I'm Anjanette Levy, and we are right in the middle of jury selection for the trial of Alex Murdaugh in Colleton County, South Carolina. Murdaugh, of course, accused of murdering his wife Maggie and son Paul back on June 7th of 2021. Prosecutors contend his life was basically in shambles. He was living a double life and murdered his wife and son because a lot of this stuff was going to start coming to light. He had been confronted that day, that very afternoon, by his law partners asking about missing millions of dollars from the firm. But Alex Murdaugh says, I didn't do this. Somebody else did this. He has pleaded not guilty, and he claims he has an alibi for the night of the murders. Ballistics evidence will be very important in this case. And just yesterday, there was a hearing, a motions hearing, about the testimony of Paul Greer and what he plans to testify to for the prosecution in this case about the ballistics evidence. There were 2 guns used in this case, both a rifle and a shotgun were the murder weapons. We know the rifle has not been recovered from statements made in court. So let's listen to a little bit of Paul Greer's testimony. He is a firearms and tool marks examiner.
Are you familiar with any studies that have concluded that projectiles fired through rifle barrels produced in the same production lot have identical markings?
I am familiar with certain studies. Some of those I participated in as part of my training that are known around the United States and internationally. That consisted of those consecutively rifled barrels. That means that they were made by a tool at the same approximate time in the same state of wear. I've also done those studies with cartridge cases, looking at the consecutively manufactured breech faces. And we as firearms examiners are aware of those markings. And in those studies, they're conducted because in the fireman tool mark identification world, if you will, if we are expecting to see those carryover of those markings, we would expect to see that on tools that are made, on barrels that are rifled consecutively, or those breech faces that are manufactured consecutively, because that's when that tool is passing over that surface one after another. And I've conducted those studies, such as the Brenda 10 barrel test, the Hamby breech face test, the Glock Ebus barrels, which all have consecutively manufactured items within them. And I was able to distinguish between those items and looking at them under the microscope, evaluating those characteristics that are exhibited on those fire components, and correctly identify and associate those with the correct information.
Okay, so that was Paul Greer, the firearms and tool marks examiner from SLED, who performed the ballistics work in this case. Linda Kenny-Bodden, your thoughts on that little bit of testimony that we heard during that motions hearing?
Well, here's where the defense is going to go. I'll give you that, okay? But they're going to start with this. This is the report they're talking about from 2009 that talked about the unreliability, or that there's no foundation, scientific foundation for this. And by the way, it's not ballistics, it's firearm and tool mark identification. They'll talk about there's no evidence of testing for the height, the depth, the width, the curvature, the peaks, the ridges, the furrows, the contours of whatever marks he is looking at. That there has been no peer-reviewed study by a proper body to what his tests have been. That he knew that when he had all these items, when he was looking at, that he knew that the quote matching one was there. That he doesn't know, he's not doing a test which is called like a black box study, where you don't know what the answers, or the answers may not be before you. So I can see where the defense is going to go, and they are going to spend a lot of time questioning him on these areas that said that he is basically giving his subjective opinion and he doesn't have any foundational validity.
I think you make some great points there. Joseph Scott Morgan, this is just a question that you and I have talked about. Gunshot residue. When Alex Murdaugh was at the scene that night and placed that 911 call, I think it's pretty obvious he was immediately a person of interest in this case, as he would be since he's closest to the victims. But we don't know if they ever did a gunshot residue test.
Well, there's some indication, I think, in one of the reports that they found particulate elements of gunpowder on the infamous shirt now that we've heard about. Here's the bigger issue for me, Anjanette. Unlike firearms examination, when you begin to talk about GSR, you're talking about something that can be quantified, qualified and quantified because it's measurable. Firearms examination, as Linda pointed out, you can't put a numeric value on it like you would with DNA, but you begin to think about GSR. Well, GSR can be rather fragile, all right? Just follow my logic here. You have apparently, and this is why I think that the shotgun is significant here, because you got two types of ammo that were fired from it. Then I think, let me do the arithmetic real quick. I think we're talking about 5 rounds of rifle ammunition that were fired, okay? So that stuff deposits onto the hands, okay? So you have a primer strike when that the firing pin goes forward, it slams into the primer. It's a little disc on the back. That is chemically identifiable. It throws up a puff of smoke, and that will land on the hand. You also have propellant smoke that comes out. It has a different chemical signature. That gets into the air. Sometimes it'll get onto the victims. And then you have fragmented lead as well, and it's particulate. It'll float down. Now, the problem is, if you have an accused person who is smart enough, wily enough to wash their hands and their arms, maybe their face and their neck, prior to being assessed by the police, you got a problem at that point in time. And right now, we don't really, from a timeline perspective, we don't know definitively when these weapons were fired precisely, and how much time elapsed between that ending time and when that 911 call was made, the infamous call. I think a lot of this, and I'm going really far afield here, a lot of this is going to come down to cell phone tower information. You know, when the calls initially came in and when people were originally spotted, there's talks of camera footage and all these things. So it's going to be a big blend of things here. But you're shot in the foot, no pun intended, prior, you know, from Jump Street, if this individual has washed their hands and cleansed himself here. He couldn't have gotten to the shirt more than likely if he's still wearing the shirt, but you can wash your hands, and the stuff is it's very superficial. That'll wipe right off, you know, particularly if you apply soap or some other agent to your hand to kind of cleanse yourself, and you do it thoroughly.
Most definitely. Gigi, I've got this question for you because we were kind of discussing this just before the show started. This comes from Krista Kelly from Facebook. She says, my biggest question is, what was on Paul's Snapchat video the night he was killed? I know we haven't seen it, but there's been some stuff kind of floating around about this, kind of out there in the news world.
Yeah, we don't know for sure yet what's on that Snapchat video, but Creighton Waters said that this is chief in the case. So whatever is on that Snapchat video clearly is critical to the prosecution's case against Alex Murdaugh right now, as far as we know.
And we saw that maybe one news agency somehow was able to obtain this video. I think we're all very eager to see what it shows because, you know, it could be a critical piece of evidence, as the prosecution says, because in a court document, they said 7:56 p.m. is when Paul sent this video to some of his friends. So it'll be interesting to note what is on that. You know, Gigi, I do want to ask you one other question as well. You know, this comes from Melissa Dotson from YouTube, and you know, you've been out there in the community. You've been there since the weekend. She says the defense knows they only need to convince one jury. A hung jury is always a possibility. Does all of the attention to this case make it difficult to ensure fairness? What is the vibe you're getting from the community there?
Well, I was just talking this morning with a lady that works at a gas station, and she saw my badge and said, "You're in town for the Alex Murdaugh trial?" And I said, "Yes." And she said to me, "He'll be found not guilty. He still has a pretty strong grip in this community." Several other people have echoed that. So a lot of the locals here feel like he will get off on this just because of who he is, even though we know now these crimes date back years and years. But that's still the feeling, is that grip on this community is still kind of tight, which also lets you know how very tight the grip was before all of this came to light.
Linda, as a defense attorney, what's your feeling on that? Because, you know, I was talking to some other people about this, that there are people who still, Eric Bland, he represents Gloria Sanderfield's children along with some other victims of Alec Murdaugh's financial misdeeds. And he said this family, they're revered in this community, but they're also feared. So what is your feeling on that? Because I feel like this trial, even though it should only be about Alec Murdaugh and whether or not there's evidence to prove beyond a reasonable doubt that he killed his wife and son on June 7th, 2021, it seems like this trial is much bigger than that. What are your thoughts?
Well, and Jeanette, you have to remember that the family also includes the two victims who whether he did it or not, were murdered, and that's what this trial is about, right? And there's a lot of people that would have known Mrs. and also the son. They also know about other issues in the community dealing with the death of Mallory Beach, if I recall. So I'm not sure that that plays out to help the prosecution or help the defense, I should say, as much as you would think it is. Now, could there be a hung juror because one of the jurors says, I don't think the prosecution proved that Alec Murdaugh pulled that trigger of one of those weapons? Or will somebody say, hey, wait a second, maybe he's so smart and so bright, because we know the family is so smart and so bright, that he set this up using two weapons to make it seem like this was two people who killed his family to set the eyes of the law away from him. So I'm not sure it inures to the benefit of the defense as much as you would think it would.
That's an interesting perspective there from you, Linda. All right, we are continuing to take your questions on our YouTube chat, Twitter, Facebook, and Twitch. So keep them coming and we will get to as many of them as we can. For now, we are going to take a quick break. Stay with us. I'm Anjanette Levy, and you are watching Law and Crime. welcome back, and thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we are taking your questions live until 1 o'clock. So please keep them coming on YouTube, in our chat, Facebook, and on Twitter. We will get to as many of them as we can. We, of course, are covering jury selection in the trial of Alex Murdaugh, who's accused of murdering his wife Maggie and son Paul back in June of 2021. Right now, the court's on a brief break. We are in the middle of that jury selection process. Kathy Russin, our executive trial producer, has been telling us that juror 202 has been excused. She said she wasn't sure she could be fair, and she has a cough. So now we're down to 79 jurors, and the judge said he wants to take a break to allow the attorneys to, quote, ponder the remaining jurors. So that'll be interesting to see what happens when we come back. In court, right before a motions hearing yesterday, or during a motions hearing, I should say, Dick Harpootlian, the lead attorney for Alex Murdaugh, talked about how Alex Murdaugh didn't have any motive to kill his family. He said they were perfect. Take a listen.
The last point I'd make is this. His theory, and this is sort of, is that he knew the jig was up, so he went home and blew the head off his son, and butchered his wife. There's not one shred of evidence there was any problems between any of them. There's texts, pictures, people that were with him the previous weekend at a ball game, video from that day with Paul and he having a good time. There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son.
All right, Creighton Waters, the lead prosecutor on the case, kind of sitting there looking like he had a lot to say. Dick Harpootlian, though, from what I've been told, a great trial attorney. Linda Kenny Bodden, tell me your thoughts on what you've seen of Dick Harpootlian so far. I've been told he is a master at cross-examination.
Well, I don't know because I haven't seen the trial, right? He's bringing all the right motions, which I'm impressed with. He's got a very difficult case in terms of pretrial publicity. But so far, except for the appearance I think that he made initially on, I think, one of the AM morning shows with this case early on. He's doing all the right things, but I think the prosecutor also knows what they're doing here. I think we're going to see a real fight in this courtroom, and a judge is going to have to keep both of these attorneys under control. But I would say one thing to you. There is no perfect family. And if you say that to any juror, they're going to think about the TV shows that we look on YouTube back from the 50s. But, you know, there is no perfect family. And you're always at danger from the one you love. And keep that in the back of your mind.
Certainly. And when he said that, I thought to myself, there is no perfect family. We know that just from living life. We know that from watching these cases here on Law and Crime. There's no such thing as perfect. So you got to be really careful with throwing that word around. Let's get back to some of our viewer questions. They were really good questions coming in, and keep them coming on Twitter, YouTube, in our chat, and on Facebook, and we will get to them. So I want to know, this is from Christy in the Carolinas from YouTube, and I'm going to throw this one to you, Gigi. She says, or she asks, who else had the motive to kill Paul and Maggie? And at least from Paul, we know there might have been a lot of people who had something against him.
Right. And that was sort of the theory in the very early days after the murder, was that maybe this was a revenge killing for what happened to Mallory Beach. But I can't think of anybody. I've never heard anybody really say there was anybody else who would want the two of them dead. I mean, it just doesn't fit. Maggie seemed to be well loved in the community. And, you know, so really the only theory I ever heard was just revenge for Mallory Beach. And that still, that was kind of hard to believe that somebody would go shoot the both of them. So I think it all kind of ties back. You know, we know that he was going, Alex Murdaugh was going to have to expose his financials just days after the murder in court, which ties back to the state's theory that this was just a diversion to gain sympathy and distract from the fact that what we now know is years and years of financial crimes.
Mm-hmm. Yeah, and I'm kind of wondering too, what would the possible motive to kill Maggie be? Why would somebody else have a beef with her to go to those lengths? So I'll be interested to see how they address that, the defense, because they don't have to prove anything, of course, but they'll still have to, address something. We have another question coming in, and Joseph, I'm going to ask you this question. It's from Anton_14A from YouTube. Have they actually placed Murdaugh at the scene at all before the call to 911? I don't know if we know the answer to that question, but what are your thoughts?
Hi, Anton. Yeah, I don't know that they necessarily have at this point, and certainly I think that perhaps if they do have that information, SLED, who is the lead agency on this now, is going to play that pretty close to the vest. I would think that the defense might have some insight into that just through their discovery, but of course they're in their gag order now at this point in time. So that's going to be a big reveal, I think, in court. Again, going into the nature of what this is going to be like. I got to tell you, I don't recall in recent memory where we have covered a case like this on Law and Crime, where this is setting up for a dogfight like this. I think that it's going to be something that's going to be quite compelling to watch kind of play out, because there are these little instances along the way. Cousin Eddie, is going to play into this.
Right.
Certainly, the evidence I see our production team is putting up this image of the shirt. That's going to come into question. And here's one more thing. I think that talk about putting him there. One thing that kind of sticks out to me, this is not like you wind up in this location by accident. I'm talking about if you're a potential perpetrator. And we're not looking for anybody. It's not like we've got a dragnet out looking for anybody. The investigation at this point is done. I think that it's quite fascinating when you think about this place geographically. If you were to do a geographic profile on this location, how isolated it is. I mean, very isolated. Ask Gigi. She's out there right now, and she's in kind of their urban center right now. You get out there in this location, and it implies, at least just by the view of it, you have to have specific knowledge, intimate knowledge of how to move about this property, because it's not something that you just randomly wind up. And then you've got these two individuals that are within, I think the yardage that we've been getting is like 30 yards separated Maggie and Paul. And then Paul is in what's referred to, it's been storage room and feed room, I've heard, thrown back and forth. Very tight, intimate space. How are you going to know that they're there? It's perpetrated at night, all these sorts of things. So a lot of that's going to come into play in this trial.
And I think if we have drone video, we have some drone footage and ground video that we took and we shot of that property. And you're right, Joseph. I mean, this is an expansive property, and there's this long road. When you enter the property at the gate, you go down this long driveway, and then, the house is there, and then the kennels are over on this other part of the property. So it's a huge, huge property. I mean, it's sold or it was on the market for more than $3 million. That gives you an idea of just how big it is. So Gigi, what do you make of that area? I mean, have you been by the crime scene?
I have not been by the crime scene, but I've seen the drone footage, and it's off the road. And in fact, that's one thing that Alex Murdaugh said on the 911 call. It's off the road. So I agree. It's not just a house you stumble upon in plain view, and it's huge. So you have to know where those dog kennels are, and they're not right by the house. So I agree. Somebody with intimate knowledge of this property knew exactly where to be to take out Paul and Maggie.
Exactly. And we just had that drone footage up for the viewers to see just how big that property is. Also, we have a diagram that was included in a defense motion. I'm going to tweet that out here in a little bit so people can see where Paul and Maggie were located in that crime scene. So we're going to take a quick break. Keep your questions coming to us on Twitter, Facebook, and in our YouTube chat, and we will answer them. So stay with us. I'm Anjanette Levy, and you are watching Law and Crime. Anjanette Levy, and thanks for joining us here on Law and Crime. We are answering your questions right here in the middle of jury selection in the trial of Alex Murdaugh in Colleton County, South Carolina. He, as we've been telling you for the last week or two, is accused of murdering his wife Maggie and son Paul back on June 7th of 2021. Alex Murdaugh says he didn't do it. Says he's not guilty. So one of the big questions in this case is the motive. And the prosecution says the motive is basically that Alex Murdaugh was living a double life. His life was falling apart. He had all of these financial pressures on him, being questioned about missing money from his law firm, having to produce financial records in a civil suit involving his son, Paul, who had been driving a boat and caused a crash that killed Mallory Beach back in 2019. So there's a lot here. And really one of the questions, and a lot of our viewers are asking this question, is, will those financial crimes, the financial misdeeds, the records come into evidence? Will the prosecution be allowed to present those? So Linda Kenny-Bodden, a decision on that hasn't yet been made by Judge Newman, but do you anticipate a lot of those financial records coming in or being allowed to come in as evidence of motive?
Well, we did hear the prosecutor say that the reason that, according to the state, that the defendant killed his wife and his son is because he was about to be exposed in those financial crimes. So I do anticipate that some mention of the financial crimes will be coming in with some kind of jury, issue in terms of telling the jury that doesn't mean, that he's a bad person, but it's going to the motive. However, if I'm the defense, I am ready for that, Anjanette, because I'm going to say, oh yeah, let it all in. You were a bad person. You deceived. You took away money from other people. You were a scoundrel. You defrauded, and you stole from many people. Well, every single person that you stole, deceived, defrauded, they are a potential future defendant, according to the defendant. They're a potential person who could have killed his wife and his son. So I'm saying, bring it on.
It cuts both ways, doesn't it, Linda? You
Yes.
can often turn those things on their head as a defense attorney, because there could have been any number of people who did this. I'm thinking to myself, I was thinking yesterday, what if somebody wanted to send a message? That could be a possible claim the defense makes. I don't know.
When we teach this at Harvard, we teach there are no bad facts in a case. The facts are put into your theme. If they don't work in your theme, they may not be good. But there are no bad facts in a case.
Very interesting perspective there. And you would be a good teacher on that, Linda, I know. Gigi and Joseph, I'll go to you first on this, Gigi. A lot of people want to know whether or not the defense is going to point the finger at cousin Eddie, Curtis Eddie Smith. He is the guy accused, along with Alex Murdaugh, of shooting Alex Murdaugh in the head almost 3 months after the homicides. Alex Murdaugh came out after claiming he was shot in the head by somebody he didn't know, that yeah, cousin Eddie and I cooked this up, or I cooked this up because I needed a $10 million life insurance policy for Buster, my only living son. Then Alex Murdaugh goes to rehab, says he's got an opioid addiction. So do you anticipate, are you getting the vibe that the defense is going to try to pin this on cousin Eddie?
I mean, they said as much in a filing not too long ago where they say he failed a polygraph test when asked specifically, did you murder Maggie and Paul? And in fact, in the filing had screen grabs of that polygraph test with the lines put in that filing. So I think it's the easiest one to go to as far as putting the blame on. He was familiar with the property. They had other dealings that I'm not sure will come into this, but he is on the witness list. So we will see if the defense goes after him, but they have made a big deal about that failed polygraph test. I'm curious to see if that's brought up, even though it's not admissible in court.
And the prosecution does not want the jury to hear about that because polygraphs are not admissible in court. An update just briefly from our producer. Yes, Joseph.
Yeah, I was going to say, I think that this idea that cousin Eddie could be, had the finger pointed at him, he is essentially a fall guy in this from one perspective. He's a target that they can reach out to. Think about everybody else that Murdaugh has had contact with, the people he's defrauded. Allegedly, we just had a settlement that has been reached with Mallory's family. And of course, they've been drugged through just a hellacious time. And then poor old Gloria Satterfield. They can't set these people up that way. they've already been beat to hell and back, essentially financially and every other way, and they've been defrauded. So Cousin Eddie is kind of a default position here. Maybe that's the direction the defense is going to go in. I can't imagine that they would, point the finger at any of these other peripheral individuals that are involved. And not to diminish the pain and suffering, but Cousin Eddie is somebody that he's been involved with throughout these number of years. He's somebody that's part of the family that they know, those sorts of things. But just having covered the Gloria Satterfield case extensively in my own way, when you look at that's a very sad situation.
Very sad situation. And one thing you brought up that we had discussed earlier, Joseph, too, Cousin Eddie would have known the lay of the land on that property. So that's one thing that could play in the defense's favor. An update from our producer, Christina Bubba, just now. She tells me that we have 7 jurors that have been selected. So we are getting closer to those 12 jurors and the final panel of 12 plus the alternates. So we're keeping a close eye on this, and we've loved taking your questions this hour, and we hope that you'll keep them coming in the days and weeks ahead. I am going to sign off now. Linda Kenny Bodden is going to take it from here. Gigi, thank you. Joseph Scott Morgan, thank you. And thank you as well. We will be right back.
What say you for the state?
What? Court's indulgence will not.
We're going to have a conference with juror number 22 right here. If you'll come here for a moment. You may proceed.
What say ye for the state?
Please excuse the juror from this particular case. Thank you.
All right. Juror number 22, you can have a seat back with the panel. Juror 729. What say you for the state?
Please present this juror.
What say you for the defendant?
Please swear this juror.
Have a please seat to your right. Juror 864.
Please present this juror.
What say you for the defendant?
Please swear the juror.
If you'll have a seat to your right, please. Your Honor, that's your 12.
Pardon?
That's the 12.
2, 4, 6, 8. No, you're absolutely right. We'll proceed with alternates.
And Your Honor, are they?
Thank
Thank you. Juror 278. What say you for the state?
Please present this juror.
Defendant?
Excuse the juror.
Thank you. Have a seat back with the panel. Juror 741. What say you for the state?
Please present this juror.
What say you for the defendant?
Please swear the juror.
You have a seat to the right, please. Juror 254. What say you for the state?
Please present this juror.
What say you for the defendant?
Swear the juror, please.
Thank you. If you have a seat over to your right, please. Juror 326. What say you for the state?
Please present this juror.
What say you for the defendant?
The number again, please.
That is 2326. What say you for the defendant?
Swear him, please.
Thank you. Have a seat to your right, please. Juror 337. Oh, I'm sorry. I apologize. It is 337. What say you for the state?
Please present this juror.
What say you for the defendant?
Excuse the juror, please.
You'll have a seat back with the panel, please. Juror 441. What say you for the state?
Please present this juror.
What say you for the defendant?
Swear the juror, please.
You'll have a seat to your right, please. Juror 704. What say you for the state?
Please excuse this juror.
You'll have a seat back with the panel, please. Juror 82. What say ye for the state?
Please present this juror.
What say ye for the defendant?
Excuse the juror, please.
If you'll have a seat back with the pen.
I believe they're out of strikes.
No, 2 and 1 each.
Two strikes. 1 and 2, as to each alternate.
Juror 530.
Your Honor, may I approach, please?
Juror 530, please come forward.
Madam Clerk, so we have, how many strikes left on this alternate? 1?
On this particular alternate, if it is per person, then you still have 2 strikes left.
No.
Oh, 1 more?
We just
Okay.
used 1.
I'm sorry, 1 more, yes.
Please present this juror.
Defendant?
State out of strikes?
They used their first strike.
They only have 1. Okay. Present the juror.
All right, this is alternate number 5. If you please be seated with the jury. Juror 548. What say you for the state?
Please present this juror.
What say you for the defendant?
Please swear this juror.
Thank you. Have a seat with the juror, please. Your Honor, that completes the 6 alternates and the 12 jurors.
Are there any matters of law regarding the jury selection?
Your Honor, please.
All right.
None from the state, Your Honor.
Ladies and gentlemen, you all have been selected to be the jury in the trial of this case, and I'll speak with you all in a moment. First, I want to thank the other jurors who are here who have not been selected, so stand by. Ladies and gentlemen, I want to certainly thank you all for your cooperation during these past 3 days, and even before then when you received this questionnaire in the mail to complete. You've now complied with your jury service. Some of you are happy and some are sad that you weren't selected. Don't know that, but congratulations having completed your jury service. Madam Clerk, do you have any information for them regarding work excuses, anything of that nature?
Yes, sir. If you do need a work excuse, you can go downstairs to the General Sessions Department, and they will be glad to help you out with that. Thank you for coming, for your service.
All right, thank you all, and you are excused. Are there any matters before the jury is sworn?
No, sir, Your Honor. Your Honor, I believe there is one matter that we need to put on the record very quickly before they are sworn.
Your Honor, we have waived any Jackson v. Deno hearings as to any statements made by the defendant to Calhoun, made on the night of June 7th, morning of June 8th, August 11th. Was there another?
3 statements.
That's on the night of June 7th.
I believe that they are waiving any Jackson v. Deno hearings with any of the statements related to the murder investigation, of which there are 4, I believe, 4 recorded statements.
That's correct.
Are there any matters before the jury is sworn?
No, sir. Your Honor.
No, sir.
All right, Madam Clerk, you may swear the panel.
I can have you stand, please. Raise your right hand. Do you solemnly swear or affirm that you shall well and truly try and true deliverance make between the state of South Carolina and the accused at the bar, and a true verdict give according to the evidence and the laws, so help you God? You will have a seat, please.
Ladies and gentlemen, you've now been selected and sworn to well and duly try this case and render a true verdict according to the law and according to the evidence, so help you God. And as long as you hold true to that oath, you will have, in the end, fully complied with your oath as jurors, and no one will have the right to complain about your verdict. We have taken the entire morning to get to this point. We have run into lunchtime. I will have a preliminary charge to give you before we get started this afternoon, but we're going to break for lunch in just a moment. As far as the jurors coming back and the parties being ready for opening statement, what says the state? What time you be ready to go?
Just a minute, so it's 1:30. Your Honor, we both believe we can be ready by 3 o'clock.
That's correct, Your Honor.
So, ladies and gentlemen, we're going to break for lunch, and I know you'll go to the jury room, get acquainted with one another, and you'll be given some instructions by the bailiff. It is important for you to know that you're not to discuss the case with each other, with anyone else, and not to endeavor to find out any information about this case other than what you will receive here in the jury, in the courtroom. So we're going to break now, go to the bailiffs, follow their instructions, and we'll see you back at 3 o'clock. Everyone can be seated. With regard to the indictments that I'll inform the jury about as to the specific charges in the preliminary instructions or during qualification, that is, we inform the jury that the charges of murder, 2 counts of that, and there are 2 counts of possession of a weapon during the commission of a violent crime. The state called all of these cases, all of the indictments for trial.
Yes, sir, Your Honor.
Is that your understanding as well, Mr.
Yes, sir, Your Honor. Yes.
All right. So I have each indictment, and I will give the jurors a preliminary instruction based on all of that. Anything else before we break for lunch? Yes, sir.
Logistical matter, we've noticed, of course we've never noticed, we didn't have any reason to look over here, but we cannot see the jury, especially these 5 or so back here with this in the way. Is there a way to move it out of the way when it's not being used?
Yeah, what is it? It looks like a TV.
Big TV set.
That's how they're going to see all the exhibits, so we'll be constantly rolling it back and forth. This is going to be a very image-heavy case, I think.
There's a way to lower it.
Well, it is.
It is.
There is a way?
Well, obviously the lawyers, the defense is entitled to see the jury at all times, and whatever problem that presents, they must have an unobstructed view of the jury. When evidence is being presented, and if it blocks the defense's view, then the defense will be moving around various places, which they
Well, then we have to bring the defendant with us.
should not have to do.
We don't want to have to do that.
So, and those are logistics that typically would have been worked out prior to now.
Well, I apologize, Your Honor. We didn't realize until we got people sitting in the jury box that we couldn't see. We don't have an unobstructed view of basically these 5 or 6 seats right here.
So you'll have an hour and 35 minutes to figure that out, to work on it, but I agree with the defense. They have to be able to see the jury. And I can't figure it out. You all have to figure it out.
Yes, sir. Do you have any suggestions?
No. Okay, well, we'll be, yes, sir, Mr. Griffin.
Yes, Your Honor. One issue, we had submitted a proposed consent order as to how to handle some sensitive exhibits.
Yes, sir.
And I don't know if Your Honor has considered that and how you wish to proceed in that regard.
Yeah, the parties have consented to and asked the court to approve an order sealing unduly sensitive exhibits. The court hasn't signed the order, but the court has granted the order, or is granting the order, and will sign it, and it'll speak for itself. The order states that there's a joint motion before the court to seal photographs and videos graphically depicting the victims, sealing that evidence which is offered and accepted as evidence in the trial to protect privacy interests of the victims' families, and to prevent emotional distress to the victims' families, as well as to ensure both the state and the defense receive a fair trial. And the court will be ordering that all autopsy photographs and crime scene photographs that and videos which graphically depict the victims to be filed under seal. They're not to be copied, reproduced, disseminated, or photographed, or otherwise made available to the public. Any party offering this evidence which the party seeks to have sealed shall prepare and file an exhibit placeholder describing generally the nature of the photograph or video being introduced. The court will permit counsel for any media organization the opportunity to inspect sealed evidence at the conclusion of the trial and to petition the court to unseal any such evidence. And unless the court issues such an order, the evidence shall remain under seal and shall not be disclosed to anyone other than the parties, their counsel, and court personnel. That order would be made available to the public, but that's exactly what it will say.
Thank you, Your Honor. Thank you, Your Honor.
All right. Thank you all. We'll be in recess till 3 o'clock. Welcome back, ladies and gentlemen. What I will say now is intended to serve as an introduction to this trial. These remarks are not a charge on the law. I will instruct you on the law in greater detail at the end of the trial before you retire to consider your verdict. But this is an explanation of the procedure that we will follow in this trial so that you may better understand what's happening. The defendant is charged with 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime, the elements of which will be explained to you later. He has pled not guilty to these charges. He's presumed to be not guilty of these charges. He cannot be found guilty unless the state presents evidence which convinces you, the jury, of his guilt beyond a reasonable doubt. The charge is simply the documents by which the case comes into court. Your purpose as jurors will be to decide the facts of this case. And out of all the people who were summoned to come here for jury duty, out of all the people who live here in Colleton County, out of all the people who live here in the state of South Carolina or any place else, only the 12 of you who will deliberate can decide the facts of this case. And you'll determine the facts of this case from the testimony which will come from this witness stand, together with any exhibits which is made a part of the record or any stipulations entered into by counsel. It is especially important that you perform your duty diligently and conscientiously and in conformity with the oath that you took, because ordinarily there is no way to correct an erroneous determination of facts by a jury. Now, just as only you can determine the facts of this case, as the presiding judge, I am the judge of the law. You must accept as correct the law as I stated to you, then deliberate and decide. I cannot tell you what the facts are. You cannot disagree with me as to what the law is, and even if you disagree, you must follow the law as I stated to you. You take the facts as you find them to be, the laws I give it to you, you deliberate and you decide the case. Until I tell you that it's time to do so, you cannot discuss the case with anyone, including your fellow jurors. You cannot discuss the case with family, friends, or anyone else. The attorneys in the case, you cannot discuss it with them or any parties or anyone else that might be connected with the case. Should you discover that a fellow juror is violating that oath and that order, you are to bring that to my attention. It's also vital that you do not seek information outside of the courtroom during the case. That means that you're not to search internet websites, watch television reports, news reports, any other form of social media accounts of the case, because you are sworn to decide this case based on the facts as you determine them to be, based on evidence presented in the case, as well as the law as I give it to you. Now, later in the process, I will appoint one of you to serve as the foreperson of the jury. And that person will have the responsibility of serving as the spokesperson for the jury. That person will have the responsibility of presiding over the jury deliberations. And that person will have the responsibility of completing the verdict form representing the unanimous verdict of the jury. In just a moment, the Attorney General will make an opening statement in which he will explain the issues as he sees it, or as the Attorney General sees it. Following that, the defense counsel will have that same opportunity. Then we'll begin with the presentation of testimony from witnesses. I look forward to working with you on this case and to keep the case moving as reasonable as we can keep it moving, but we will not rush, but take the time necessary to have this case fully presented to you. We'll now proceed to opening statements by the state.
Thank you, Your Honor. May it please the court. On the evening of June 7th, 2021, at the defendant's property off Moselle Road in Colleton County, his son, Paul Murdaugh, was standing in a small feed room in some kennels they had on the property. About 8:50 p.m., and the defendant over there, Alex Murdaugh, took a 12-gauge shotgun and shot him in the shoulder, in the chest and the shoulder, with buckshot. And the evidence is going to show it was a 1,000,000-to-1 shot. He could have survived that, but after that, another shot went up under his head and did catastrophic damage to his brain and his head. The evidence is going to show that Paul collapsed right outside that feed room. And just moments later, he picked up a .300 Blackout, which is a type of ammunition, but an AR-style rifle. And the evidence is going to show that the family had multiple weapons throughout the property. Picked up that .300 Blackout rifle and opened fire on his wife, Maggie, just feet away near some sheds that used to be a hangar. Pow, pow! 2 shots, abdomen and the leg, and took her down. And after that, there were additional shots, including 2 shots to the head that again did catastrophic damage and killed her instantly. The evidence is going to show that neither Paul nor Maggie had any defensive wounds. Neither one of them had any defensive wounds, as if they didn't see a threat coming from their attacker. And the evidence is also going to show that both Maggie and Paul were shot at extremely close range. The evidence is going to show it's called stippling. It's almost like a tattoo, that when you get shot very close to a weapon, it leaves marks that the forensic pathologist can see. They were shot at close range and they did not have defensive wounds. And the evidence is going to show that the defendant, Alex Murdaugh over there, told anyone who would listen that he was never at those kennels. But the evidence is also going to show from these things that every one of us, most of us carry around in our pocket, that he was there. And he was there just minutes before, with Maggie and Paul, just minutes before their cell phones go silent forever and ever. Despite what he told people, I was never at those kennels, the cell phones are going to show otherwise. Ladies and gentlemen, my name is Creighton Waters. I'm with the Attorney General's office and I'll be the lead prosecutor. I introduced myself before. With me is David Fernandez, Savannah Gow, John Metters, Don Zelenka, John Conrad, and Johnny James. A lot of lawyers. This is a big case. It's a very complicated case, and that's why there's so many people working on it. Sitting back in the row, we have David Owen, who's the lead investigator. We have Lieutenant Charles Gent, who's one of the agents, Special Agent Ryan Kelly, and Special Agent Peter Rudolphy. Some of the agents that are working on the case, as well as Investigator Isaac Toledo, who's working on the case as well. There's some of the witnesses that you'll hear from as we go through this case. The judge talked to you a little bit about him being the judge of the law, and he gives you the law. And I'm going to talk a little bit about some of the legal concepts before I turn back to those facts. Just remember, though, he's the judge of the law, so you take what he says But I'm going to explain to you some of the legal issues from my perspective before we talk a little bit more about the evidence in the case. And the first thing is right before you went to lunch, y'all all took an oath. Everybody in this courtroom who's got involvement in this case takes an oath. You know, attorneys take an oath to become an attorney, take another oath to become a prosecutor, judge takes another oath to become a judge, witnesses take an oath on the stands, law enforcement take oaths to become law enforcement, but y'all took an oath as well. And the reason why is that y'all have the most important job in this courtroom. Every one of you raised your hand and said that you would well and truly try this case. And it's the most important job here because like the judge said, he's the judge of the law, but y'all are the judge of the facts. Y'all are going to listen to what comes from that witness stand and judge those facts. But you also have to be mindful of that oath. That oath requires you to do that hard job, to make that decision, to call the strike when you see it. It's the same oath. It's just as important as any other oath. This might be the most important in this courtroom. The judge mentioned reasonable doubt, and he's exactly right. It's the state's burden to prove this case beyond a reasonable doubt. That is a cornerstone of our country. I wouldn't have it any other way. It's a burden we welcome. It's what we want. It's a system that has been well tested and true, and we take that burden to prove the case beyond a reasonable doubt. And I want to remind everyone that the emphasis is on reasonable. Okay? It's not any doubt. It is reasonable doubt. Reasonable doubt is often defined, and again, listen to the judge how he defines it, but reasonable doubt is a doubt that would cause a reasonable person to hesitate to act. To hesitate to act. And when you hear the evidence coming from this stand about this particular case, I submit to you, you won't hesitate to act. Again, remember the emphasis is on reasonable and reasonable doubt. The judge mentioned the charges, and there are 4 of them. First indictment accuses Alex Murdaugh, to which he's pled not guilty, but it accuses him of murdering Maggie Murdaugh. The second indictment accuses him of murdering Paul Murdaugh. The third indictment accuses him of possessing a firearm during the commission of a violent crime, that being the murder of Maggie Murdaugh. And the last one accuses him of possessing a firearm during the commission of a violent crime, and that being the murder of Paul Murdaugh. And what does that mean? What is murder? Well, the judge again is going to instruct you that it is the unlawful killing of another with malice aforethought. And what is malice? Malice is a mental state. That's ultimately going to be for y'all to determine as to what was going through Alex Murdaugh's mind when he committed these crimes. What is malice? Malice has often been defined as the intentional doing of a wrongful act without just cause or excuse. It is the intent to inflict an injury under circumstances that the law would presume an evil intent. An evil intent. And when you look at the circumstances of the crime, when you look at what led up to this crime, the evidence is going to show that there was malice aforethought. Aforethought, what does that mean? It means it has to exist at the moment you commit that crime. It doesn't have to be planned. It doesn't have to be planned for any long period of time. It just has to exist a split second before the crime is committed. But when you see this crime and you hear all the circumstances, the evidence is going to show that aforethought existed for a while. It existed for a while in the mind of Alex Murdaugh. You're also going to hear about circumstantial evidence. And a lot of times people hear, oh, it's just a circumstantial case. But the law says otherwise. The law says that circumstantial evidence is just as good as direct evidence. And what's the difference between the two? Direct evidence is supposedly about to storm out here, from what I'm told. Direct evidence is if it's sunny outside, and a witness goes outside and it's sunny, and they come in here and they get on that witness stand, and because they saw it raining, they sit on the stand and said, I was just outside and I saw it raining. I saw it raining. That's direct evidence. They actually saw it raining. But to give you an example of what circumstantial evidence is if the witness goes into a room where all the curtains are drawn, and when they go into that room, it's sunny outside and everything's dry. And while they're in that room, they see it darken behind the shades. They hear thunder. They hear the wind blowing. They hear the sound of raindrops on the roof, and then they open up the door, and it's not raining, but everything is wet. There's puddles in the driveway, there's puddles in the street, there's puddles in the yard, there's limbs down all over the ground. And then they come in here and say, yeah, it was raining. Didn't actually see it raining, but those circumstances are beyond any reasonable doubt that it was actually raining. Now, I guess it's possible that somebody could have been standing outside their window and beating a drum to sound like thunder and blowing a fan to make it seem like it was the wind and somehow got enough water to coat the entire neighborhood. But that's not a reasonable doubt. Everybody understand that distinction? That's not a reasonable doubt. Another thing, and this is crucial, what you're going to do in this particular case, is determine credibility or the believability of witnesses. So it'll be your job to look at the evidence, the exhibits in the case, but also the witnesses, and decide if it's truthful, if you believe it, if you can rely on it. And the judge is going to instruct you that you can believe one witness against many or many witnesses against one. You can believe all the witnesses' testimony or part of the witnesses' testimony. It's up to you, first individually and then as a product of your deliberations. And what you're required to do there is just to rely on that good old-fashioned common sense. Does it all fit together? Is it corroborated? Does it fit with what you would expect? Does it fit with what you expect how real people would act? Does it seem real? Or does something seem a little off? Does something seem a little off? You're going to see video statements of Alex Murdaugh. You're going to see body-worn camera of him at the scene when law enforcement arrives. And hear what he says. And hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement. And you're going to hear how things progress about what he says and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right? Or does something seem a little off? Something seems a little off about this. I mentioned that Maggie was killed with a .300 blackout rifle, an AR-style rifle that chambered in .300 blackout ammunition. And you're going to hear evidence that back in Christmas of 2016, Alex Murdaugh over there bought 2 .300 blackout AR-style rifles. And then not long after that, one of them went missing from Paul's truck. And time went by, and in April of 2018, Alex Murdaugh replaced that rifle and bought another one. 3 total blackout rifles that they had. One of them went missing years ago, and a replacement was bought. You're going to hear evidence that Paul and his friend were using that replacement gun. They were standing right outside the side door to the gun room of the house, and they were sighting it in, firing down into a field. And the cases were ejecting. The cases are the empty shell from a bullet, and they were ejecting out into the flower bed right there. And then there's a range across the street, and they shot it there, and there's cases ejected there as well. And they were shooting that 3rd replacement gun just weeks prior to the murders, prior to June 7th, 2021, when Maggie and Paul were murdered. And you're going to hear forensic evidence that the cases that were found in that flower bed and the cases that were found across the street at that range were ejected out of the same weapon that fired all the cases that were around Maggie's dead body, that killed her. It was a family weapon that killed Maggie Murdaugh. And you're going to hear evidence that of those 3 blackouts that Alex Murdaugh purchased, when law enforcement arrives at the scene on June 7th, 2021, he can only account for one of them. He can only account for one of them. And that replacement gun is nowhere to be found. You're also going to hear evidence that the type of ammunition, the exact brand, the exact model of ammunition that was used to kill Maggie, S&B, 300 blackout ammunition, and 147 grain bullets, that exact ammunition, boxes, empty boxes of that ammunition, is found all over the property. The very same brand and model of ammunition that was used to kill her is found at multiple locations throughout the property. And you're also going to hear evidence, the same thing about the shotgun shells that killed Paul. That federal double-aught buckshot unfired rounds were found on the property, as well as Winchester .2 turkey loads, the 2 rounds in the shotgun that killed Paul. Family weapon, same ammunition. It's on the property. You're also going to hear evidence that about a week after the murders, Mr. Alex Murdaugh's father had died, Mr. Randolph. And about a week after the murders, he shows up early in the morning at his parents' home, where his mother still is in late-stage Alzheimer's, on Alameda in Hampton. It's uncharacteristic for him to show up early, uncharacteristic for him to show up at all like that. And he comes in, and he's carrying something in a blue tarp, and he takes it upstairs. And eventually law enforcement finds out about that. And they go upstairs, and they find a wadded up, very, very large raincoat in a blue color. Could look like a tarp. And you're going to hear evidence that it was coated with gunshot residue on the inside. On the inside. You're going to hear other evidence of gunshot residue. You're going to hear that there was gunshot residue on Alec at the scene. You're going to hear the evidence that there was gunshot residue on the seatbelt of the car he was driving. You're going to hear evidence that when law enforcement got to the scene, he had gone and gotten a shotgun, Paul's shotgun, and that Maggie's DNA was on that shotgun. You're going to hear other evidence from DNA, gunshot residue, firearms examiners. There's going to be a lot of forensic evidence in this case. And I'm not going to get into every single bit of it right now, but I will say that a key piece of forensic evidence that you're going to hear in this case is the cell phone evidence. Alex's cell phone, Maggie's cell phone, Paul's cell phone. You know, this is all amazing technology that most of us carry around in our pockets. It really allows us to do a lot of things and to get a lot done. But this cell phone keeps track of who we're talking to, who we're calling, who we're texting, whenever we access apps. And every time you do that, there's a record kept in this phone unless it's deleted somehow. And if you're using certain apps, you can even get GPS information where you were when you did that that's stored on these phones. You're going to hear evidence about that. You're going to hear evidence that when you make a call and it pings off of cell towers, that location information can be gathered from that as well. And so it allows an investigation to take this and piece together what someone was doing on a particular day, and not only what they were doing, but who they were interacting with and how they were interacting with them. And this is going to be crucial evidence for you to consider. You're going to hear that particularly Alec and Paul, but also Maggie, were prolific cell phone users, to the point where Paul's friends even had a nickname for him about his cell phone usage. Before I talk more about that, there's 3 family properties I need to talk about. Okay. The first one I've mentioned is Moselle. Moselle in Colleton County. It's called Moselle. It's off Moselle Road, but everybody refers to it as Moselle. And that property is it's a lot of acres. There's a main house on it, and there's a driveway that goes to that main house. But it used to be an airstrip, and there's an airstrip that goes down, and then down the way, just less than a third of a mile away, just a 3-minute walk, 4-minute walk, 45-second drive, is the kennels and the shed that used to be a hangar where Paul and Maggie were murdered. So the main house is just less than a third of a mile away. You can see the kennels from the main house. You can see the main house from the kennels. The family also had a house in Edisto at the beach. And the evidence is going to show that that is where Maggie preferred to stay, particularly in the summer months. She liked the beach. She was not a hunter. She didn't want to be at Moselle. She didn't want to be at the lodge where it was hot and buggy. She liked being in Edisto. And then you're also, I've already mentioned, the house in Alameda, which is where his parents' home. On June 7th, 2021, you're going to hear evidence that his father went into the hospital and the prognosis was not good. And in fact, he died a few days later. And his mother was in late-stage Alzheimer's and that house being cared for by a caretaker, and you're going to hear from that caretaker.
Mr. Waters.
Yes, sir.
Have you pause for a moment? We'll be at ease for just a moment.
Yes, sir, Your Honor.
You may proceed.
Thank you, Ron. All right. We were talking about the three family properties. Moselle, who has the main house, and the kennels / sheds. The main house has a driveway, but the kennels also have a driveway. And the evidence is going to show that that was actually as commonly used as the main driveway. In fact, the mailbox is by the kennel driveway. Driving right past those kennels were Paul and Maggie were murdered. I told you that you're going to hear evidence that Maggie did not like being in Moselle as much as she liked Edisto, the beach house. But that, on June 7th, 2021, she came back to Moselle. And the evidence is going to show that she arrived about 8:15. And the evidence is going to show that from the cell phones that Paul was there at the house, at the main house. And Alex Murdaugh himself says that they ate dinner. And the autopsy is going to reflect both Paul and Maggie having similar stomach contents, indicating that they recently shared a meal together. About 8:30, but 15 minutes after they arrived, Paul's phone starts moving towards the kennels. You're going to hear evidence again that the defendant said he was never at those kennels, that he was napping after they ate, and he was at the main house and never went there. You're also going to hear evidence about how much Alec used his own cell phone, and it would be unusual for him to be anywhere without his cell phone. At 8:44 and 55 seconds, Paul recorded a video. He was down at the kennels because he had been talking to a friend of his. And you're going to hear from this friend because his friend's dog was in the kennels and they thought there was something wrong with the tail. And Paul was recording a video of it to send to his friend. 8:44 and 55 seconds. And on that video, and you'll see that video, and you'll hear from witnesses that identify Paul's voice, Maggie's voice, and Alex's voice. Told anyone who would listen he was never there. At 8:44 and 55 seconds, there's a video. The evidence will show that he was there. He was at the murder scene with the two victims. And more than that, just over 3 minutes later, 8:49 and 1 second, Paul's phone locks forever. He never reads another text. He never sends another text. He doesn't answer calls. 3 minutes after that video has the defendant at the murder scene with the two victims, Paul's phone goes silent forever. And in fact, another communication comes into the very friend that he was talking to the dog at 8:49 and 35 seconds, just 35 seconds later, and he doesn't answer it. He never answers another thing forever and ever. And on top of that, Maggie's phone locks at 8:49 and 31 seconds, around that same time, and she never answers another text, never sends another text, never makes another phone call, never receives another phone call. 3 minutes, ladies and gentlemen. 3 minutes after a video shows he's at the scene with the victims, and he told everybody he was never there. Never there. Credibility, ladies and gentlemen. Credibility. So what happens after that? Well, you'll hear evidence that Alex's phone was conspicuously, didn't have a lot of activity from about 8:09 p.m. until 9:02 p.m. And if he was at the kennels, which the evidence will show, why is his phone not with him? Why is it not showing activity? But you will hear that at 9:02, all of a sudden his phone does start to pick up activity. At 9:02, he starts moving. At 9:04, he calls Maggie's phone. Doesn't answer, of course. Doesn't answer. He calls his father, Randolph, who's in the hospital. Doesn't appear there's an answer there. He calls Maggie again at 9:06. Remember, he's just a third of a mile away. You can see it. At 9:06, she doesn't answer. At 9:06, he turns on his car, his Suburban, and he texts Maggie that he's going, be right back. I'm going to go check on Mom. And he doesn't drive down to the kennels, even though that's where the mailbox is. That's a common place to be, even though you can see it. He's called his wife 2 times and texted her, and she hasn't responded. But he didn't just drive down there and say, hey, I'm heading. You guys want to go? What's up? What's up? Right there. You can see it. He then drives to Alameda. where his mom is suffering from Alzheimer's, and the caretaker is there. And he starts calling people. He's talking to people. It'll be up to you to decide whether or not he's trying to manufacture an alibi. He gets there to Alameda. You'll hear evidence about whether or not that was usual. You'll hear evidence about how he was acting when he got there. And he's only there for 20 minutes because he's back underway at 9:44. And he makes more phone calls on the way back. Calling friends, calling people who will answer. It'll be up to you to decide whether he's trying to create an alibi. And he gets back to Moselle at 10:01. And he calls 911 at 10:06. Listen to that 911 call. Listen to what he says. Listen to what explanations he may offer. You're going to hear that 911 call, but you're also going to see the body-worn camera of the officers who arrived at the scene. The video camera they wear so that it records what they're doing. And you're going to see what he did to Maggie and Paul. It's going to be gruesome. There's no other way around it. It's what he did. You're going to see crime scene photographs. You're going to see the traumatic injuries that were suffered. You're going to hear from a pathologist, a doctor who will examine the injuries. It's going to be gruesome. There's no other way around it. On that 911 call and on the body-worn cameras, pay attention to what he says. Look at how he's acting. But he says within a few minutes of each one of those, he says, this is about the boat case. This is about the boat case. And you're going to hear some of what was going on in Alex Murdaugh's life leading up to that day. Stuff that happened that very day, stuff that was leading up, a perfect storm that was gathering, much like the storms that are coming outside today. Listen for that evidence. Listen to that gathering storm that all came to a head on June 7th, 2021, the day the evidence will show he killed Maggie and Paul. This has been a long, exhaustive investigation. And it's going to be a fairly long trial because it's complicated. It's a journey. There's a lot of aspects to this case. There's a lot of factors to this case. But like a lot of things that are complicated, when you start to put them all together, piece them together like a puzzle, all of a sudden the picture emerges and it's really simple. It's really simple. Once we get to the end of that journey, and you have a chance to deliberate, the evidence is going to be such that you're going to reach the inescapable conclusion that Alec murdered Maggie and Paul, that he was the storm, that the storm was coming for them, and the storm arrived on June 7th, 2021, just like the storms that are heading here right now, that they died as a result, beyond any reasonable doubt. Thank you.
For the defense.
Please report, Your Honor.
Yes, sir.
Ladies and gentlemen of the jury, my name is Dick Harpootlian. I think I introduced myself to you all and the attorneys, the three other attorneys, Jim Griffin, Philip Barber, Margaret Fox. It is our honor to represent Alex Murdaugh, or Murdaugh, depending on how you pronounce it. I say it's our honor because I submit to you what you have heard from the Attorney General as facts are not. They're his theories, his conjecture. Now stand up. This is Alex Murdaugh. And Alec was the loving father of Paul and the loving husband of Maggie. You're not going to hear a single witness say that their relationship, Maggie and Alex's relationship, were anything other than loving. You're going to hear about how they went to a baseball game the weekend before. You're going to hear about their relationship. You're going to see texts and emails indicating a loving relationship. Paul, the apple of his eye. You're going to see a video somewhere between 7:30 and 8 o'clock the night of the murders with Paul and Alec riding around looking at some trees they planted. It's a Snapchat that Paul sent to other people because the trees were not planted very well. They were cantilevering over. They're laughing. They're having a good time. That would be about an hour before the Attorney General says he slaughtered them. When I say he slaughtered them, when they were slaughtered, and no question, Paul Murdaugh was shot twice with buckshot, 12-gauge buckshot, once in the chest. And by the way, that shot would indicate it was in the chest and came out under his arm, like somebody that might have been holding up their hands. So when he says no defensive wounds, he perhaps was being held at shotgun. I mean, I can make the same sort of speculation that the Attorney General can, because that's all he's doing is speculating. What we do know is 12-gauge, fairly close range shot to the chest. He must have been turned because it comes out under his arm. There's wadding, if you're familiar with a shotgun, under his arm. The second shot ended up, and there's going to be some question about the direction of that shot, but ended up entering his skull cavity, and the gases from that shot literally exploded his head like a watermelon hit with a sledgehammer. All that was left was the front of his face. Everything else was gone. His brain exploded out of his head, hit the ceiling in the shed, and dropped to his feet. Horrendous, horrible, butchering. So, to find Alex Murdaugh guilty of murdering his son, you're going to have to accept that within an hour of having a extraordinarily bonding, you can see it in the Snapchat, that he executes him in a brutal fashion. Not believable. Not believable. Now, Maggie is shot running. There's no defensive wounds because she's shot running, and after she falls to the ground and has one bullet that has hit her and probably traveled up and hit her brain, she's on the ground, and whoever the perpetrator was walked up, took that AR, and put one in the back of her head. Executed. Executed. Why? This is going to be interesting because we don't know why. He doesn't know why. He's got theories of this and theories of that. But why? Number one. Number two, what was it in that hour between when he's yucking it up with Paul? And let me say this to you. He was interviewed. He comes home and finds, there's no question about this, they've got telemetry from his car. He left the house at 9:06, returns at 10:01 after seeing his mother who has dementia. Now remember, that day, his father, who is dying, is taken to the hospital. Mom's home alone with the housekeeper. Perfectly reasonable for him to want to go see her. And later than usual, because his father's not there. He's in the hospital. He dies 2 days later. His father dies 2 days later. So the question is, if he leaves at 9:06 and he's back at 10:01, he literally, and he can account, the cars and the cell phone records account for where he was between 9:06 and 10:01. Now the cell phone records, and you're going to hear this from their own experts, are incomplete. They're incomplete. And we submit one of the reasons they're incomplete, and by the way, how do they find Maggie's phone? Maggie's phone was thrown out on the side of the road about a quarter of a mile away from, a little bit more, maybe a half a mile, from the Moselle property, thrown out on the side of the road. They found it by using Find My iPhone. And the way they did that, they had to open it or have access. Who gave them the code to open the phone? Now, Murdaugh. And it's not destroyed, it's just thrown on the side of the phone. What you're also going to see is that Alex Murdaugh was calling that phone at 9:06. As he leaves the house, he did call her twice and texted her. And we also know that at 9:06, as he cranks his car, as the cell phone records show that, as the telemetry data shows the cell phone linking up with the car, that phone is being thrown on the side of the road almost a half a mile away. Now that is Houdini. That is magic. That is inexplicable. Now, I was making notes while the Attorney General was talking. But let me tell you what is more believable. The night he comes home and finds his wife and son butchered. And when I say butchered, you're going to see these photographs. When I see them now, after having seen them for the last 4 or 5 months, it still shocks me. It still is tough to look at. It still bothers me. And he comes home and finds his son laying in his own blood with his brain laying at his feet, shot to hell. He walks over, he checks to see if there's any life there, although, he's seeing his brain laying outside his body. He knows there's nothing there. He goes over and tries to get a pulse out of Maggie. No pulse there. Calls 911. I want you to hear that 911 tape. It is a man hysterical, in grief, trying to figure out what's going on. And he tells the 911 operator that he's concerned, and he drives back up to the house. And by the way, you can't see, I've been out there, you can't see the shed where you might see the top of the shed. There are pine trees between the front porch or the porch on the house and the dog pens. And it's not a third of a mile, maybe by the way the crow flies, but it takes a little bit longer to drive down there. And this is not unusual for them to communicate by cell phone or text, even when they're all on the same property. It's 1,100 acres. Big property. They hunted it. So, what I'm trying to say to you is that the Attorney General has given you his view. And again, you can't see the shed. And I'm going to ask the judge at some point during this trial to ask you, the jury, to be able to go to the scene so you can see it. You can understand the proportions. You can understand the details. Because the facts are what matter here. The facts. Let me give you another fact. You're going to hear their witnesses explain the catastrophic injuries to Paul. That his head literally exploded. And whoever shot him with that shotgun was probably no more than 3 feet away. Maybe closer, maybe a little further away. His head exploded. You would be covered in blood from head to foot. Head to foot. In blood. They seized his clothes that night. SLED did. And they well, first of all, you're going to see in the videos from the officers that arrived that night, there's no blood on him. They didn't find any blood on him. SLED's testing indicated 12 different places on his shirt and pants. No human blood detected. Period. Okay? You'll see pictures. A white t-shirt, no blood on it. Those are facts. Those aren't theories. Those are facts. Another fact that is, I think, the reason we're here today. When you hear those questions on the videotapes on the night, now he's found his wife and son brutally butchered. You can hear on the 911 tape, he is hysterical. He comes in and out. It's consistent. If any of you have ever, you got to use your experience as part of this deliberation process. Your human experience. If you've ever suffered the catastrophic loss of a friend or a family member, it's numbing. The minute you find out, or if you see them dead, it's numbing. You go into shock. So anything he said that night is in the context of just an hour or two before finding his wife and son butchered. He drove back up to the house while he was on 911 saying, I got to get a gun. Whoever did this might be out there. And he gets a gun. But what's fascinating about that is he gets a 12-gauge shotgun and he grabs some shells. These people hunt a lot. They have guns everywhere. He grabs some shells. He puts a 16-gauge, a 12-gauge, grabbed a 12-gauge shotgun, put a 12-gauge buckshot in, and then he put a 16-gauge buckshot in. That's how shook up he was. Guy hunted all his life, and he put a shell in that he couldn't fire a 16-gauge from a 12-gauge. Makes no sense. He was traumatized. GSR, their own expert at SLED said the amount of particles of GSR are consistent with him going up and picking that shotgun up. They want to talk about GSR? Again, if you fired a shotgun twice and a rifle 6 times, you'd be covered in GSR. Those are the facts. That's not his theory. The facts. Now let's talk a little bit about these ARs. Again, you're going to hear testimony. A lot of guns. They had a gun room. I don't live in Carlton County. I live in downtown Columbia. Ain't no gun rooms in downtown Columbia. But apparently if you live on 1,100 acres and you hunt deer and you hunt whatever they were planting those sunflowers for, quail, again, a big number. You have a lot of guns. The truth is, in 2017, and you'll hear the testimony, that Alec bought 2 Blackouts, one for Paul and one for Buster, his other son who's sitting out in the audience. And Paul had his stolen. He bought another one for Paul. Now, Paul was very irresponsible with guns, cars. He'd leave guns around. He'd leave guns in cars. He oftentimes left guns down at the dog pens, in the feed room. Now, I can't tell you whether he was shot with his own weapon or not, or his mom was shot with his weapon or not. But I can tell you that they weren't shot by Alex. They don't have the guns. There's no way to tell conclusively without having the weapons what weapons those were fired by. And we'll be talking a little bit with the SLED experts about that. The sort of overarching issue here is why murder on June 7th, 2021, why is it September of 2022 before they charge him? And I will tell you what happened that night. And this is a problem. He's questioned, and the questioning is pretty aggressive. You'll hear it. He's traumatized. They suspect him. They show up, he's got a shotgun. They suspect him. And the next morning, 2 people found butchered here in Carlton County, Moselle Road. The police announced, don't worry. There's no danger to y'all. There's nobody out there that could pose a danger to you. Because you see, they decided that night he did it. Without forensics, without cell phones, without any of that. And they've been pounding that square peg in the round hole for the last, well, since June of 2021, resulting in charges in September of 22. And so, if he felt, and he did, and you'll hear it, the accusatory fashion he's being interviewed in, he may not have dealt all the facts. But by the way, whether he'd been down to the dog pens that night or not, really didn't matter. Really doesn't matter. Because you're going to see cell phone activity that would be, let me put it to you this way. Paul's phone, 8:50. Maggie's phone, later than that, 8:54. Clearly, is still being used. At 9:06, he's up at the house getting in the car, cranking it up to drive over and see his mom. He says a few hundred yards away, it's a little bit further than that. But the point of the matter is, he would have had to have executed both of them, got back up to the house, got the bloody clothes off, and by the way, they seized his clothes from that night. They've never searched his house for any other clothes that we know of, although that night he gave permission and they got a search warrant. Go to my house. Go look through everything. Where are the bloody clothes? Where are the bloody clothes? And of course, I would tell you that they've woven this story together because they want everything to be consistent. What's important about that is the judge, and by the way, there's no eyewitness. There's no forensics tying him to the murder. When I say forensics, fingerprints, blood, whatever, tying him to shooting anybody that night. The cell phone records would indicate he would have had less than 10 minutes to kill him, get up to the house, get in the car and crank it up. He'd be covered in blood. Now, if they think he was beginning to establish an alibi, there's no evidence of that. The evidence is consistent with him seeing them earlier at the dog pen. And by the way, that audio they have of him and Maggie, they're talking about one of the dogs killing a chicken. And they were debating whether it was a guinea hen or a chicken. No animosity. Very normal discussion. Paul's very happy. And we know that Paul, after that, is texting back and forth with a girl about going to the movies. Nobody's down there threatening him. Daddy's not pulling out a shotgun and killing him. For, 10 minutes after that, he's texting this girl. So, big question. One shooter or two? Two guns, shotgun and an AR. And by the way, Maggie has no defensive wounds because she's running. What's she running from? And could you shoot? Typically she had a little shed right, probably 150 feet from the feed room on the other side of a wall. Perhaps she heard the shotgun blast and came around and saw somebody or two people, and whoever it was opened up. Was there enough time to kill Paul and then find the AR and then ambush Maggie? Much more likely there were two people, but again, we don't have to prove anything. Let me sort of share the framework in which you should examine this. You have agreed to follow the law, and here's the law. Here is the law. He didn't do it. He is presumed innocent. As you sit there right now, when you look at him, you have to believe he is innocent. He didn't do it. Now, let me tell you, that's so difficult to do. I get it. And the way maybe the best way to explain it is this. This morning or yesterday, nobody really reads newspapers anymore, but if you're reading the newspaper, looking at the internet, and you read the police had arrested somebody for for some heinous crime. The natural inclination of everybody, all of y'all, is to say, thank God they caught him or her. Thank God that person is in custody. And you did something that's so natural. We all do it. You presumed the police had arrested the person that committed the crime. You presumed him or her guilty. That is the natural thing to do. And you know what? That's fine for you to do. Any other day except today. Because you took an oath to follow the law. And the law is, he is innocent. He's presumed innocent. That is your presumption. Your mental framework is, he didn't do it. They've got to prove it to me beyond a reasonable doubt. Now, what's even more difficult, and this isn't a contest, this isn't a game, this isn't who wins and who loses. This is about justice. You know, Oliver Wendell Holmes, one of the justices of the Supreme Court, once said, jury duty is the highest duty a citizen can perform for their country in peacetime. Because you are protecting us from them, from the state, from the government. That's the foundation of our Constitution, is that the individual has the right to be presumed innocent, has the right to a jury trial, has a right to have his or her peers sit in judgment of it. That's you. And the framework is you presume him innocent, and you cannot convict him until the state proves to you beyond a reasonable doubt of his guilt. And a reasonable doubt is the kind of doubt which would cause an ordinary person to hesitate to act in the more important decisions in their life. Now, what makes this even more complicated is there's no direct evidence. There's no eyewitness. There's no camera. There's no fingerprints. There's no forensics tying him to the crime. None. None. I say that without any fear of contradiction whatsoever. None. And what the judge is going to tell you is, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. Now, this smoke they've created is about suspicion. I mean, if you show up at the scene and you got the wife, the wife especially dead, and the guy's got a shotgun, you know, it's pretty logical for the cops to jump to a conclusion. He did it. And the problem is that as they came to that conclusion, they have pounded that square peg in the round hole, and you're going to hear about it. They've ignored some witnesses. For instance, that blue tarp showed up with a blue tarp. That witness who said he showed up with a blue tarp was shown a blue rain jacket that he talked about. Said, that's not it. That's not what he brought here that morning. I've talked to her. She says, no. It was a blue tarp. And what was it?
I object to him testifying, Your Honor. Objection sustained.
I would indicate.
Strike as well, Your Honor. Objection sustained. You may proceed.
I would tell you that the testimony you're going to hear is inconsistent with the Attorney General's represented to you, based on interviews done by people other than me. So, what I'm telling you is this, that as you sit here and listen, every time there's a witness that takes that witness stand that the state's put up there, you see, you judge the credibility, whether to believe a witness or not believe a witness, whether to believe one witness against many, many against one. You're going to have to evaluate the testimony you hear from this witness stand with a critical eye. Critical eye. If you've got uncontested scientific evidence, you accept it. I've got no problem with that. These cell phone records he keeps talking about, I would say to you, are not necessarily accurate to the extent they're reliable. I will also tell you that there's going to be a bunch of people, and I will that have been promised something or threatened with something that may take the witness stand and say something. But I tell you what they're not going to say. They're not going to say they saw him kill him. They're not going to say that they were involved in it. They're not going to say anything that would give you a comfort level in their testimony. Now, all of you have indicated that you will follow the law. And I say this one last time. He didn't do it. He didn't butcher his son and wife. And you need to put from your mind any suggestion that he did. You've been picked because you said you could be fair. You were picked because you said you could follow the law. You were picked because Alex Murdaugh believes that you can be fair. Now, if during this process over the next however long we're here, I say something or do something, which most certainly based on my career I will do, that irritates you or angers you, sometimes I'm a little rough. Don't hold that against Alec. Hold it against me. If I say something that offends you in some way, don't hold that against Alec. Hold it against me. Remember, as you sit there right now, in your mind, he didn't do it. He is innocent. He would require a verdict of not guilty from you. That's the law. That's your oath. Thank you.
Ladies and gentlemen, I'm going to send you to the jury room for a break while I discuss scheduling with everyone. Please do not discuss the case. As I mentioned to you earlier, you're not allowed to discuss the case at all until you've heard the entire case and you've heard the instructions of law. So please go to the jury room. For scheduling, do you have a witness you want to call today?
Your Honor, I think as we have talked to your law clerk, we do have a witness. Unfortunately, that witness, the main point of that witness would be the body-worn camera, as he is a first responder that arrived at the scene. Unfortunately, the audio does not appear to be working, so I'm informed, despite efforts of courtroom staff and even our IT folks to try to get it going. I've been also told that the company that installed this for the court is not here, and they've been able to do this. So, unfortunately, given the lateness of the hour, which I don't think we could finish him anyway, because the video in and of itself is fairly long.
9:30 tomorrow morning, they still haven't done whatever you just said.
I will personally come up with a solution to present evidence to this jury, but I think, I don't even think we could really get him done today anyway if we started, because even the body worn itself is 20, 30 minutes, something long, depending on which exhibit we put in.
Yeah, and I think this is wise because even if we started right now, I don't think you could get the whole video played. And I'm going to ask, and I'll tell the Attorney General now, we're going to ask him to play the whole video for completeness rather than picking out little excerpts. So that may take 45 minutes.
Any objection to that?
We had prepared excerpts. There's a lot of discussion of law enforcement as they're arriving at the scene, and I have theories. But if he wants to play the whole thing, I'm fine with that.
All right, settles that. Okay. If you bring the jury, I'm going to excuse them to 9:30. If they're ready to come in. A few minutes waiting for the jury to get ready to come in.
Please be seated.
You can bring the jury in. Get them to come in. It's 18 people. All right. Thank you, ladies and gentlemen. We are through for the day. We're going to recess till 9:30 tomorrow morning. Remember the oath that you took and the instructions that you're not to discuss the case with anyone. You're not to engage in any search for further details through any means. And we need you back at 9:30 tomorrow morning following the instructions given to you by the bailiffs as to where to report to. You'll never come through the courtroom to get to the jury room. And we'll see you at 9:30 tomorrow morning. You may go. All right. We're in recess as to the jury. Go. If everyone will be seated. Just a couple of things with regard to the daily transcript. Is that what is the problem? Is that system? Can someone tell me? Is that it?
Yes.
Okay. Well, this transcript is not an official transcript. It's not the official court reporters are the two South Carolina judicial branch employees and not the company that produces this transcript that those in the media or the parties may be interested in purchasing. Want the parties to acknowledge that they understand that any transcript produced by anyone other than the court reporters is not a verified true copy transcript.
Your Honor, we understand that. Absolutely. Both of us, though, have a concern that this microphone, and we've expressed, if it's picked up conversations between us and our client, or we're concerned that that not appear in the daily transcript.
All right, and the transcript, that microphone is by the same outfit? Whose microphone is it?
We're told when that clock in front of you is on, it's on, right?
Yes. That microphone, the microphone on the AG's table, the microphone in front of the clerk's bench, and the microphone you are speaking into that has the mute button, those are FTR, or the record microphones. That's what's giving you the daily transcripts. And it is also tied to the PA system.
So I don't really care about the daily transcripts. My problem is that we can't get audio in the courtroom, and that's what we're going to try to fix tonight.
Well, we're talking about one thing right now.
Yes, sir.
So with regard to the for the record transcript, the non-official, and is that where the problem is now with that you all have been working on, or is that now been resolved with that company?
The problem with STR and the draft transcript, the daily transcripts, that is working fine. When we had to move some of the equipment around earlier, it messed up some of the wiring.
For the audio?
Yes, sir.
All right. And is that what you're working on, said you'll be working on overnight or something?
Yes, sir. We're going to come up with a solution that's independent of any of the court-provided facilities, and we'll come up with something. I'll go home and get a guitar amplifier if I need to. But yeah, we'll get something done.
Is there anything else before we break for the day?
None from the state, Your Honor.
Nothing for the defense. 9:30. Am I correct about that?
9:30.
Yes, sir.
All right, court will be in recess till 9:30.